Good day and welcome to the Loss Control webinar series. Today's presentation is titled Preserving Products After Adverse Events, FDA Compliance and Product Liability Risk Management. I'm Courtney Stevens, an attorney in the Loss Control Department at Medmarc. On behalf of Medmarc and today's presenter, Beth Rose, thank you for joining us. Beth is a member of Sills Cummis Gross, where she is chair of the Product Liability Practice Group and a co-chair of the Litigation Practice Group. She has tried complex product liability cases to verdict in state and federal courts throughout the country. She is the lawyer to whom general counsel turn when they need an aggressive but practical approach to vet the company product liability matters. Clients rely on her expertise to develop successful and cost-effective strategies consistent with their business goals. Beth has over 25 years of experience successfully defending complex product liability matters for a variety of regulated products, including pharmaceuticals, medical devices, consumer products, foods, chemicals, and construction and industrial machines. She also has experience defending product liability cases which arise from clinical trials and catastrophic workplace accidents. Her practice ranges from single plaintiff cases to state-coordinated proceedings, multi-district litigation, and class actions. During her career, Beth has served as national counsel to several companies, including those in the pharmaceutical, medical device, and contract research organization spaces, defending mass tort litigation. She has also served as New Jersey counsel to entities defending complex product liability claims in New Jersey's multi-county litigation system. With that, I am pleased to turn things over to Beth, who will begin today's presentation.
Well, thank you, Courtney, for that kind introduction. I'm really pleased to be participating in Medmarc's series. As you noted, today's topic is FDA regulation versus product liability law. How do you clean up after an adverse event? The purpose of the webinar is to discuss best practices for dealing with returned products, especially those that are the subject of a customer complaint or an adverse event. And throughout my remarks, the focus will be principally on medical devices rather than pharmaceuticals because, in my experience, the return product issue arises mostly in connection with medical devices. So the areas for discussion today will be first the regulatory landscape, and what I'm going to do is provide a brief overview of the relevant FDA regulations and guidance documents that have talked about how to handle returned products, and in most instances it's really what they don't say that will be significant to our discussion. I'll then turn to the tension between FDA regulations and product liability law and give a few scenarios to try to set the stage. We'll then look at selected case law, and I'll review certain general principles of preservation and spoliation and highlight some cases that I think really bear on a manufacturer's obligation to preserve return product that might be the subject of an adverse event for litigation purposes. And then finally, we'll round out the discussion with some practice pointers, and hopefully you'll agree after you hear some information about the case law that some of the principles from the case law really can inform a medical device manufacturer about how to fashion certain standard operating procedures. So with that, let's look a little bit at the regulatory landscape, and specifically the regulations that deal with medical device reporting and what constitutes a reportable event. Many of you on the phone are no doubt very familiar with these regulations. You kind of live and breathe them every day, and so you're probably aware that a manufacturer's obligation to report an event arises when that manufacturer becomes aware that one of its medical devices may have caused or contributed to a death or a serious injury, or that there was some sort of malfunction, and similarly that the malfunction of the device might be likely to cause or contribute to a death or serious injury, especially if that malfunction were to occur. In both instances, the medical device manufacturer has a duty to investigate and evaluate the cause of each event. What is interesting for our purposes about these regulations is what the regulations do not say and the areas that they don't cover. On the one hand, the regulations are very specific in terms of reporting, and there are guidance documents that provide great detail about the do's and don'ts of MDR reporting. But what I haven't been able to find is any requirement regarding how the device is handled in certain circumstances. For instance, I haven't found any requirements that the device be preserved or destroyed after reporting and investigation requirements are met. I haven't found any requirements about devices being maintained or stored for a certain period of time. Both the time of retention and the manner in which the manufacturer deals with returned products seems to be, in large measure, within the discretion of the manufacturer. I was also interested in looking at the regulations regarding malfunction. And the reason I was interested in those regulations was because often when a medical device is returned to the manufacturer, it's because the user has claimed that there has been some sort of malfunction. So the slide we're looking at now defines malfunction, pretty straightforward, the failure of a device to meet its performance specifications or otherwise perform as intended. But I took a look at the guidance document regarding MDR reporting, and I looked at frequently asked questions that the agency puts in the guidance document and then proposes answers. And there was one that really caught my eye that I thought was worthwhile discussing. The question, and I'll just quote, is, how much effort must I make to get information about an event, meaning an adverse event, or even to get the device back? Sometimes when I call a user facility, no one wants to talk to me. How many times must I call or write before I can close the file? Well, by the way, in typical FDA fashion, the answer does not contain a specific number of attempts that a manufacturer must make to before it can stop. The FDA says there has to be a good faith effort. But the answer that the FDA gave, in my view, clearly showed that the agency wants a medical device manufacturer to obtain custody of the device. And what I have on this slide is the relevant part of the answer for how the FDA answered that question, should I try to get the device back? And the answer that the agency gave was, in regard to getting the actual device for analysis, even though we can't mandate, we can't require a user facility to return a device to you for analysis, we strongly encourage them to do so. So clearly, even though the agency may not have a specific regulation on this topic, it seems to be FDA's clear preference that the medical device manufacturer make a reasonable good faith effort to get back or to get into its own custody a medical device that has potentially malfunctioned. There are also regulations related to non-conforming events. And again here, and probably not surprisingly, the regulations are predictably, broad brush or very high level. So there are regulations that require each medical device manufacturer to have procedures related to non-conforming products. And part of those procedures relate to how a medical device manufacturer would dispose of non-conforming product or rework, retest it, reevaluate it. Similarly, there are regulations that require each manufacturer to have CAPA procedures. CAPA, as I'm sure you all know, stands for Corrective and Preventive Action, and each manufacturer is required to establish procedures that include requirements for returned product, that provide for an investigation of a cause of a nonconformity, and develop a series of actions to correct or prevent a problem. CAPA isn't required for all adverse events But for those adverse events where it is required, each manufacturer must have procedures to address it. Now, of course, what is absent from regulations related to non-conforming products and also the regulations regarding CAPA is what to do with a non-conforming product once the analysis is complete. I have, in preparation for this webinar, taken a look at some of the standard operating procedures that I could from clients or just publicly available. Sometimes companies have very specific requirements about how to deal with returned products. Sometimes they don't. I would imagine that most manufacturers would prefer not to have returned product lying around indefinitely. Some companies may have SOPs that build in timelines for when returned product needs to be discarded. And herein, I think, lies some of the tension between the regulatory environment and medical device manufacturers trying to follow good practices and product liability law. And I've just come up with two hypotheticals here on this slide, but I think that they are reflective of some of the issues that the industry is facing. So the first scenario is that the company decides to retain a medical device beyond the time limits in its SOP. And the reason that it does that is because it wants to preserve the medical device for litigation purposes. The FDA subsequently comes in, does an audit, and finds that the company has violated its own policy, and that violation is noted in the Form 83 that's issued after the inspection. Similarly, you could envision a situation where a product is returned, there is an investigation as part of a root cause analysis or a CAPA analysis. There's destructive testing, litigation follows, and there's a finding that the manufacturer has spoliated the evidence. So with that background, I'd like to talk about some of the relevant legal principles that I think will inform us about what type of information or what type of guidelines we would want in an SOP. And I start with principles of preservation and spoliation because they really are key to this discussion. Many of you who are attorneys or who have litigated matters no doubt know that the general rule is that the duty to preserve attaches when litigation is commenced, in other words, when a complaint is filed and you get notice of that filing, or that litigation is reasonably anticipated or foreseeable. And in the last, I'd say 10 to 15 years or so, there has been a pretty detailed body of case law that has developed related to preservation. But most of the discussion has focused on electronically stored information like, email and text messages. And it's important to remember that these preservation principles apply equally to tangible items like medical devices. So that if a medical device is returned to the manufacturer and there was a duty to preserve it, that's called spoliation, and there are significant implications for spoliating evidence that I'll turn to in a minute. The quotes on this slide is from a case called Silvestri, Fourth Circuit 2001 case that I thought did a really nice, had a nice discussion about preservation principles in this context. And, you can feel free to download the slides and take a look at these quotes and even look at the case. But the three really principal takeaways are that it's not just destruction of evidence that's important, it's also material alteration of the evidence. Second, these principles apply pre-litigation, and I would imagine that in most situations when a manufacturer is getting the return product, there may not be litigation. And so there may be a tendency to, not really have the preservation principles center in your mind. And third, even if you don't have possession or control of the device, you may have a duty to notify the opposing party of the fact that the device is about to be destroyed. And these situations, we'll talk about some of the case law a little bit later, arise where sales representatives are present in the operating room and have access to, but not really control over the medical device. And in the discussion of preservation, I just want to be clear that it's not only a medical device manufacturer that has the obligation to preserve relevant evidence. That is an obligation that is imposed on all parties, and often it's really the plaintiff who bears the brunt of the failure to preserve. And these cases, both Bowman and Cooper, make it clear that it is a plaintiff who is bringing in action alleging injury as a result of a defective product, who has a duty to preserve the product so that a defendant can inspect it. And similarly, Cooper teaches that a party has a duty to preserve evidence that's essential to a claim or a defense. Now, there are lots of bad things that can happen to a party if evidence is not preserved and it is considered to be spoliated. And I've identified on this slide the potential consequences of medical device spoliation, and I've tried to put them in, not that anyone would ever want to be sanctioned or any party would ever want to be sanctioned, but kind of like the least severe to the most severe. So the least severe being, a fine to a party and counsel, the most severe being dismissal of a specific claim or defense or judgment in favor of the prejudiced party. And what I thought was really interesting in reviewing the cases on this issue, that more often than not, the sanction is not the imposition of fines or attorney's fees. The sanction is actually the dismissal of a claim or the entry of judgment in favor of the prejudiced party. So that if you lose email, I really haven't seen many electronic discovery cases where the sanction is judgment in favor of the party that has spoliated the evidence. But in the cases that I'm about to discuss with you, summary judgment, judgment on the pleadings, dismissal of a specific claim is often deemed to be the only remedy that's available. So I think what that really shows is how high stakes this can be. So with that, let's talk about some of the cases that I think bear on this issue. The first case is a case out of the Eastern District of New York, Burgos versus Sadie. And this is a case where the medical manufacturer, the medical device manufacturer, had physical control of the device and destroyed it. And the chronology is this, that first the case involved a device called a transoral gastroplasty stapling system. The chronology is that in November 2008, the plaintiff had surgery. The surgery was unsuccessful, and during the surgery, the plaintiff tore her esophagus. It's not clear from the case, and it looks like it wasn't really clear from the facts exactly when the device was returned to the manufacturer, but the case noted that it was sometime between November 2008, obviously after the surgery, and April 2009. And at some point during that time period, the manufacturer destroyed the device. It's also not clear why the device was destroyed. The company did have an SOP that provided for destruction of returned non-commercial devices within 3 months, and this particular device was deemed to be a non-commercial device. So if the company had followed its SOP, it would have retained the device for 3 months. So also in April, in the beginning of April 2009, the manufacturer sends a letter to the plaintiff offering to pay for lost wages and medical expenses and says, hey, if you want to try this surgery again, we will pay for that as well. There's no further communication between the plaintiff and the manufacturer until over a year later, when in September 2010, by that time plaintiffs had hired a lawyer, and the lawyer sends a letter requesting preservation of the device and also wants to inspect it. And of course, by this time, the device has been discarded and it's nowhere to be found. So the plaintiff brings an action, alleges that there's a manufacturing defect. And there is a plaintiff moves for summary judgment based in part on the fact that the defendant who actually had the device destroyed it and disposed of it. And basically what the plaintiff argued was that the defendant should have known that litigation was imminent, and when litigation is imminent, there is this duty to preserve. Because the device had failed during the surgery, the defendant took possession of it, and they had obviously, sent this letter offering, some type of remuneration. Now, the court denied the motion, and the court, here's what the court looked at. There were three principal things that the court looked at. First, the court looked at whether relevant evidence had been destroyed. Second, the court looked at whether or not there had been any culpability, in other words, whether or not this was intentional conduct. And third, whether the defendant was under any type of duty to preserve. And the court denied the motion. The court found that even if the defendant destroyed the device in violation of its own SOP, there was no evidence that it had been done willfully, and maybe it had been done negligently but not willfully, that the plaintiff had signed a consent form where a torn esophagus was identified as a potential injury. It wasn't really clear to me why the court thought this was important, though, although maybe this was not really a true adverse event in that it was something that was potentially expected. And then finally, the fact that the plaintiff hadn't filed the complaint until June 2010 and hadn't requested the device until September 2010, well over a year after it was the defendant's policy to destroy the device. So the manufacturer was not penalized in that one. As I look at the facts in this case, my takeaways from it are that all adverse events, so all return products, do not automatically trigger a duty to preserve. In some respects, it would be nice if there were bright lines, but there clearly are not bright lines. Things are very fact-sensitive. And second, that culpability can be a very important factor in determining whether or not there's going to be a sanction. I'd like to talk next about the Evans versus Medtronic case. This is a case where the manufacturer did not have physical custody of the device, but there were sales representatives who were present during the surgery where the device was replaced. There were actually two sales representatives in the operating room. And the relevant kind of high-level facts is that this case involved a Medtronic spinal cord stimulation system. It's a device that is intended to alleviate chronic pain. This was the second revision surgery. There were two Medtronic sales reps who were present. And during the surgery, this is a pretty complicated system and there are different leads. But during the surgery, the surgeon determined that the lead was unsalvageable. So he removed it, he handed it to the scrub nurse, and the scrub nurse threw it away. The plaintiff claimed that the sales reps had a duty to preserve the explanted lead, or they should have notified her in some way that it was about to be destroyed. And the plaintiffs moved for an adverse inference, and that motion was denied. And here's what the court had to say about why it denied the motion for the adverse inference. First, the court found that the sales reps didn't really have a reason to anticipate that there would be litigation related to this damaged lead. The testimony was that during the surgery, there hadn't been any discussion about a product defect. And in fact, the focus during the surgery had really been on the conduct of one of the physicians, because one of the physicians had been said to be like tugging on the lead. And next, the court found that there was no reason to know that the plaintiff had been actually injured during the surgery itself. The sales reps really never had possession, custody, or control of the lead because it was handed from the doctor to the nurse. The plaintiffs had argued, interestingly, that there was a duty to retrieve the lead based on the FDA reporting requirements. And the citation to the CFR here is to the MDA reporting requirements I talked about earlier, but the court rejected that. And finally, it also found that the time frame, the fact that this happened so quickly during the surgery, mitigated against finding any type of willful destruction of evidence. And so the motion for the adverse inference was denied. But there was, I thought, kind of an admonition of sorts from the court that I'll read to you, and you can take a look at the case and, I guess, form your own conclusion. But basically what the court said was, in hindsight, it would have been prudent for them, meaning the sales reps, to retrieve the lead or notify the plaintiff of its disposal. But their failure to do so, or to do this at most, would fall more along the lines of negligence rather than willful conduct. So, in short, the manufacturer was not penalized, but there was, I thought, kind of a warning or kind of a point that, it's important for sales reps to be aware of some of these issues when they're in the operating room. The next case, estate of LeMay versus Eli Lilly. This is another case involving sales representatives, but there's a much different outcome here, because here the question of spoliation served as a basis to allow the plaintiffs to pursue a claim that would have otherwise been preempted under the medical device amendments. And again, I think that it's significant in that it shows that this terrific preemption defense that manufacturers of Class 3 devices have can be really undermined by some of these failure to preserve issues. So in this case, briefly, this was also a products case. It was a Class 3 pacemaker. There was surgery, and the testimony was that one of the pacemaker leads had fractured during the surgery. The surgeon and the nurse both testified that they had given a broken portion of a lead to defense sales representatives who, again, were present at the surgery. The sales reps testified that they didn't remember receiving the lead, and the manufacturer said it didn't receive the lead. There was a former employee whose job it was to examine products that had been removed from patients. And initially, she testified that she had recalled examining the plaintiff's lead. And this was significant because there was also testimony that an examination of the lead would usually reveal the cause of the malfunction. She changed her testimony, though, after she reviewed company records. So there were some, questions of fact as to whether or not the sales reps and the company itself ever got possession of the lead. So the court granted the motion to dismiss on preemption grounds, but basically allowed the plaintiff to pursue a parallel claim based on the defendant's negligence in potentially failing to manufacture the device in accordance with FDA regulations. So, I'm pretty defense-oriented, so I see this as a total runaround of medical device preemption. But for our purposes, the important points are that the court basically found that if a jury found that the defendant had intentionally destroyed the lead, that the jury could infer that if you had examined it, it would have revealed that there had been a failure to meet FDA regulation. And the court also found that once defendant had possession of the lead, federal law required it to preserve the device. Now, I'm citing to 21 CFR 820.162 because that's what the court cited to. And of course, as I'm reading the case, I go straight to the CFR to find that section, and it no longer exists. It existed in a 1996 edition of the CFR, but it's not there now. These next series of cases are a little bit different. I say whose preservation duty is it anyway, because I want to show and illustrate to you that it's really the plaintiffs who are often, well, I don't want to say suffering, but really impacted by their own failures to preserve medical devices. And in some respects, I think it makes sense that a lot of the case law relates to plaintiff's failure to preserve, in that often the plaintiff will try to retrieve the medical device following a surgery or a particular event and will retain custody of the device as opposed to returning it either to the hospital or the manufacturer. So there are two cases. There's Bowman and another case called Criazza. Bowman is a penile implant case where the penile implant malfunctioned and explant surgery was scheduled. Litigation must have been on the mind of the plaintiff because the plaintiff retained counsel months before the explant surgery. And so 2 months before the explant surgery, the plaintiff's counsel writes to the surgeon asking that the prosthesis be preserved after it's removed so it can be examined by appropriate engineers to determine the cause of the breaking. Unfortunately for the plaintiff, the surgeon discarded the prosthesis following the surgery. He had died at the time the case was being litigated. And so the defendant moved for judgment on the pleadings. And the court, this was in the district court, affirmed judgment on the pleadings for a defendant as a sanction for spoliation of the evidence. The court applied a test that is used throughout the Third Circuit in Schmid. It looked first at the degree of fault of the party who altered or destroyed the evidence. And the plaintiffs argued, kind of, what do you want from us? This isn't our fault. We had our lawyer make a specific written request that this implant be preserved. The court disagreed and found that the fact that even though the plaintiffs had requested preservation and the evidence was discarded really in contravention of what they asked the surgeon to do, that fact did not relieve them of their preservation obligation. It remained squarely on the shoulders of the plaintiffs. They found that the degree of prejudice suffered by the defendant was really significant and noted a difference between manufacturing defect claims and design defect claims. When you have a design defect claim, it's not so important, or may not be so important, that the actual device that is implanted or used on the plaintiff be examined. If there are, a million devices and they all have the same flaw, then an argument could be made that the defendant could look at any one of them. But in a manufacturing defect action where the alleged defect is unique to a particular product, that the device is really the primary source of evidence. And without the ability to examine the implant, the manufacturer is really left to guess at what caused the malfunction, really, if there is a malfunction. Here, there was no ability to question the surgeon about what had occurred during the surgery, what that surgeon had observed. So the court found that the degree of prejudice was really significant. And then the third factor was whether or not there was a lesser sanction that could be applied. And again, the court found that because the prejudice was so severe that there was no lesser sanction. So that case was dismissed. In Criazza, it was similar. It's a similar result in spite of the plaintiff's attempt to preserve the device. So this case also involved a Medtronic device. Here there was litigation that was started even before the explant surgery. And prior to the explant surgery, defense counsel sent the plaintiff's counsel a proposed stipulation that provided for preservation of the device, examination of the device, and there's specific language in the letter and the stipulation that defense counsel sent in, making it clear that the reason for doing this was to avoid spoliation issues. The plaintiff's counsel would not entertain the stipulation, but did ask the hospital to retain the device. But the plaintiff then didn't follow up for 2 years. So literally 2 years after the surgery, they're now going back to the hospital, asking the hospital for the device, and of course by that time it had been lost. Just like the case we talked about a moment ago, the appellate division confirmed dismissal of plaintiff's claims based on spoliation. Again, the court found that plaintiff had responsibility for spoliation, that because this was a manufacturing defect case, it really did require the inspection of the actual device. And plaintiff's effort to kind of distort this into a design defect claim really didn't fly. There are other cases that talk about the differences between spoliation in the context of manufacturer versus design defect that you're free to take a look at your leisure. The last case that I'd really want to focus on is Cooper versus United Vaccines, because it deals with destructive testing, and this is an issue that comes up fairly frequently. So obviously FDA regulations require some type of investigation into a malfunction, but the type of testing that's done and the notice that's given prior to such testing are really important. In this particular case, this is a case not involving a medical device, but rather it was a vaccine, and the vaccine had an impact on minks, specifically the size of a mink herd and the quality of its pelts. The plaintiff complained about the vaccine and alleged that the vaccine was defective. But a year prior to starting the lawsuit, the plaintiff engaged in destructive testing. And the testing that was done was with the only leftover vaccine that they had. And to add insult to injury, the method that the plaintiff's expert or consultant or whoever did the testing was done was inappropriate. So actually the testing itself was worthless. It was impossible to know whether or not the vaccine was effective or not. But from the plaintiff's point of view, because the plaintiff engaged in this destructive testing, they had never given the defendant any notice or the opportunity to participate in the testing, to comment on the testing. The sanction was dismissal of their case. So that's an important takeaway when you're thinking about the nature and extent to which medical devices that are returned are tested. And if you have any case that's coming close to trial, Husky versus Ethicon is the pelvic mesh case, and it shows that there really can be some implications at trial if a medical device is not preserved. So just to kind of round things out in terms of what some of the teaching points are from these cases with respect to standard operating procedures and practice pointers. Whatever procedure your company has that relates to return product, make sure that you address preservation of returned product for litigation purposes. These are all very fact-intensive situations. There's no one-size-fits-all. So if as a general matter, it's preferable for your particular product that returned product is kept for 30 days or 60 days, there really needs to be some type of carve-out for returned devices that are potentially going to be the subject of litigation. And it should provide for consultation with in-house counsel or outside counsel if you don't have outside counsel about how to deal with those particular devices, so that you can avoid a situation where the FDA is taking the position that by preserving a particular returned product that the company has violated its own procedure. And obviously, medical devices that are preserved for litigation purposes, there needs to be a provision in the SOP to address how do we dispose of those goods after the preservation obligation ends. For example, a case may settle, a statute of limitations may run. Second, the SOP should provide for appropriate storage of retained samples, also of returned products, so that people know where they are, how to get to them, and the status quo is preserved. Third, proper documentation for receipt of all returned medical devices, including contacts with a potential plaintiff or his or her counsel. One of the teaching points, I think, from the cases I've discussed today is that there wasn't enough documentation and follow through, and that ended up prejudicing either the plaintiff or the manufacturer. Four, and this is something that I didn't really expect to be adding to my list, is the importance of training sales representatives, in addition to complaint handlers and regulatory folks, about these SOPs and what their preservation obligations are. Given that so many sales reps find themselves in the operating room, or sometimes they're involved in conversations with surgeons about devices, it's important that they recognize, what some of the triggers are, so that they can request a device or come back and tell the regulatory folks, so that the regulatory folks can put the appropriate people on notice. And finally, there need to be protocols for destructive and non-destructive testing of returned products. It's not recommended to conduct destructive testing without first notifying a potential adversary, getting that adversary's consent, or having that person participate in the testing itself. So those are my, words of wisdom or remarks for today, and I'll turn the program back over to Courtney.
Thank you very much, Beth. All right, looks like we do have a couple questions here. We don't have the instructions for accessing the Q&A log, but it's on the bottom right of your screen, and you can enter, type your question, and then make sure it goes to all panelists. So we'll start here. This person says, they've heard that there are changes to the Federal Rules of Civil Procedure that go into effect at the end of this year. Do any of those rule changes impact preservation of medical devices?
Well, this person is correct. There are changes that are about to go into effect in December if Congress doesn't do anything, and it looks like Congress will not do anything on the proposed amendments. And while there are changes, proposed changes to rules regarding electronic discovery and preservation of electronic discoveries, the rules related to preservation of tangible evidence are going to remain the same. The advisory committee did at one point start to redraft some of the rules related to preservation of tangible items, but thought better of it. So the rules will remain the same.
Okay, thank you. Another one. Wouldn't it be better if SOPs for return goods did provide specific time periods to destroy return medical devices?
Well, I suppose on the one hand, It would be preferable. It would be easier for people at medical device companies to, have a program where the SOP is enforced. And in some situations, that may be okay. But where you have a returned medical device that is the subject of an adverse event and could be the subject of litigation, a policy that provides for destruction within 30 or 60 days is really not going to be sufficient and is going to put the manufacturer in harm's way if there is ultimately litigation.
Thank you. Another one, this person says, would the company, determining that they need longer-term storage in consideration of future litigation, give rise to an allegation in a lawsuit, even the company thought they'd be sued over this instance if there were actual litigation?
No, I don't think so. I think that it is very common and prudent to have standard operating procedures that provide for all different contingencies. And, fortunately or unfortunately, litigation is a cost of doing business sometimes. So planning for it, I don't think that there's any disadvantage to a company to doing that.
Okay. What if after an adverse event and you get your return product back, you need to destructively test the device to see whether it meets specifications and thus whether it's the fault of a contract manufacturer?
Well, before engaging in any type of destructive testing, I think you need to consult with the contract manufacturer. You need to try to find out the context in which the device malfunctioned or potentially malfunctioned. If there's a potential plaintiff or potential lawyer out there, you need to do some, a lot of due diligence before that destructive testing takes place. I was involved several years ago in a case involving a mattress. There had been a hospital bed, and there had been a really terrible fire. And the allegation was that this hospital bed had potentially caused the fire. And to the credit of, I think, one of the carriers, anyone who had a product or a piece or a component relating to this hospital bed was notified. There was an inspection where everyone was permitted to come. The testing was arranged at a third-party site. There was notice given to everybody so that everybody could come, inspect the hospital bed, photograph the hospital bed. There was disclosure about what type of testing was going to be done. I thought in that situation it was really done correctly, even though it's difficult, admittedly, to sometimes find all these different, people and companies, but it is important not to act too hastily.
Thank you. Another question. Looks like we have time for just a couple more. I know you've been talking about manufacturers. Do these same obligations and duties for preservation also apply to medical device distributors?
That's a good question. In a product liability suit, anybody who's involved in the chain of distribution can be potentially liable. But my guess is that a medical device distributor is probably less likely to receive the returned product. But if the medical device distributor does receive the returned product, then yes, I would say that the same obligations that inure to the manufacturer would be applied to the distributor.
Thank you. And last question, Beth. Why do you think courts are more inclined to impose their ultimate sanction or dismissal when it comes to loss of a medical device?
I think that that's because in these situations, most times the allegation is that the product has malfunctioned in some respect and that it's a manufacturing defect rather than a design defect. And so the inability to inspect the product, to have an expert inspect the product, really severely prejudices the manufacturer's ability to defend the lawsuit. And that in that case, the only way to really kind of right the ship or level the playing field, so to speak, is to dismiss the case against the manufacturer.
Great, thank you. I think that's all the time we have for Q&A. If we didn't get to your question or you think of something later, you can email us at Medmarc, or I think Beth's got her contact information on the screen now. Thank you so much, Beth. I think this presentation was definitely useful to all our listeners and people that want to access it on our website in the future. Thank you for joining us. This concludes today's webinar.